All right, folks, we're going to get into the pretrial and trial procedures. First, we start with bail. So once you've been arrested, you're given an opportunity to post bail. Bail is a cash bond or some other security provided to the court to ensure the appearance of the defendant at every stage of the criminal process. The defendant's failure to appear will result in the forfeiture of the bond or security, and without bail, the defendant will remain in custody pending trial. So bail is used to make sure that you show up to your court appearance. That brings us to the right to bail, which is part of the Eighth Amendment, which guarantees protection from excessive bail. Many state statutes place no limit on the amount of bail a judge may impose. Those who cannot afford bail stay in pretrial detention, which imposes serious financial burdens on the state and local governments. So the state really wants you to post bail so they don't have to pay for you while you're waiting for trial. The restriction on excessive bail may be interpreted to mean the sole purpose of bail is to ensure that the defendant returns for trial. It can not be used as a punishment or to coerce or threaten. So if you're really, really wealthy and a judge feels like you might not come to trial, well, then they'll give a much higher bail price than they would for somebody who doesn't have that type of wealth. An important case here is Stack versus Boyle, where the Supreme Court found bail to be a traditional right to freedom that prevents the criminal defendant from being punished prior to conviction. It also held that bail is excessive when it exceeds an amount reasonably calculated to ensure the defendant will return for trial, or it is about the same as the amount set for similar offenses. And then higher bail can be imposed when evidence supporting the increase is presented. Something like they might flee if you don't make the bail super high. Of course, there are bail release mechanisms. If a felony case, or in felony cases, bail is set at a formal hearing. Issues such as type of crime, flight risk, and dangerousness are taken into account. For pretrial release programs, staff often interview arrestees and present recommendations. A prior record here is extremely important. We know that the significant majority of criminal defendants are released on bail. About 60% of felony defendants are released, and more than half of violent criminals are released before their trial. You have types of bail. You have full cash bail, where the defendant pays the full bail amount out of pocket. You have a deposit bail, where the defendant deposits a percentage of the bail, 10% with the court. And then when the defendant appears in court, the deposit is returned. You have a surety bail. The defendant deposits a percentage of the bail amount, typically 10%, to a bonding agent who posts the full bail. Remember, folks, you do not get that 10% back from that bonding agent. A conditional bail, whereas the defendant is released after promising to obey some specified conditions in lieu of cash, such as attending a treatment program before trial. An unsecured bond, where the defendant is released with no immediate requirement of payment. However, if the defendant fails to appear, he or she is liable for the full amount. And then you have those that are released on recognizance, where eligible defendants are released without bail upon their promise to return for trial. There's some characters that we run into, and they create some bail issues. Bondsmen and bounty hunters can be a problem. Some things to consider when we think about bail. It can be discriminatory because it works against the poor. It's costly because the government must pay to detain those defenders who cannot make bail. It's unfair because a higher proportion of detainees receive longer sentences than people released on bail. It's dehumanizing because innocent people who cannot make bail suffer in the nation's deteriorated jail system. And there's also a racial ethnic disparity found in the system. We find some places where bail reform is being considered. First, the Manhattan Bail Project, and of course, the Bail Reform Act of 1966 and 1984. Next step, of course, is charging the defendant. This is known as the indictment process and can result in the grand jury. A grand jury was incorporated into the Fifth Amendment and can act as an independent investigative body throughout the court process. It can act as a community conscience in determining whether the accusation of the state justifies a trial. Essentially, will they issue either an indictment or no bill at all? And there are some critiques of the grand jury. They meet at the request of the prosecution, and it's closed to the defense and the public. And it's often viewed as a rubber stamp. This leads us to the information process and the preliminary hearing. So, the grand jury, in and of itself, was conceived in English common law. The Magna Carta, signed in 1215, stated that no freeman could be seized and imprisoned unless he had been judged by his peers. This was, of course, brought to the American colonies and embedded in the Fifth Amendment. Grand juries are comprised of individuals who met at the request of the prosecution in a closed secret hearing, as we mentioned before. They also conduct their own investigations. The reports from these investigators are called presentments. The grand jury makes one or two recommendations to the court, either an indictment, as we talked about before, or a no bill. The indictment is the action by a grand jury when it finds probable cause exists for the prosecution of an accused suspect. No bill, the action taken by the grand jury when it votes not to indict an accused suspect. Some things to think about when we do charge the defendant. In reference to the grand jury, some states refer defendants solely to the grand jury. Other states have an option of bypassing preliminary hearings and referring straight to the grand jury. These powers include investigation and charging. Witnesses are presented by the prosecution, and the product, of course, is an indictment. The preliminary hearing, on the other hand, some states use preliminary hearings as a step to trial. Others use hearings to bind over to a grand jury. And the product of a preliminary hearing is information. And the use of standard proof is essentially probable cause. That leads us to the arraignment and ultimately the plea. An arraignment is a formal hearing wherein the defendant is informed of the charges against him or her. After the charges are read, the defendant may enter one of the three pleas. Guilty, which is an admission of responsibility for the offense and sets in motion a sentencing phase. Not guilty, which is a statement of no responsibility for the offense. This is verbally entered by the defendant or entered by the court if the defendant stands mute before the bench. Enim nolo contendere, which literally means no contest. The defendant does not accept nor deny the charges, but agrees to be punished. It may not be held against the defendant as proof in a subsequent legal matter, such as a civil lawsuit, because technically there has been no admission to guilt. Plea bargaining is very common, as we saw in our first discussion. Plea bargaining is the exchange or prosecutorial and judicial concessions for pleas of guilty. Normally, a bargain can be made between the prosecutor and the defense attorney in one of four ways. First, the initial charges may be reduced. Second, the initial counts may be reduced. Third, the prosecutor may promise to recommend lenient sentence. And third, a change or charge to avoid social embarrassment. Ultimately, these methods result in lesser sentences, especially sentencing policies which limit judicial discretion. Plea bargaining is a cornerstone of the informal justice system. More than 90% of criminal convictions are the result of bargains. Even in serious felony cases, plea bargaining can be an option. Pros of the plea negotiation, well, they reduce overall costs of criminal prosecution. It improves the efficiency of the court. Prosecution can devote more time to serious cases. It allows defendants to avoid detention and trial, and devotes resources to cases that need far greater attention. This is just a moment to remind you that if everybody went to trial for every offense that was committed, our legal system would stop operating. There's just too much crime to get through to take everything to trial. So when they say improves efficiency of the court, what they're really saying is that the court cannot handle the volume of cases that are being brought before it, and therefore the plea bargain is an opportunity for it to solve this problem of time. The cons to a plea negotiation: it encourages defendants to waive their constitutional right to trial. It may lead to more lenient sentences for dangerous criminals. It raises the danger an innocent person can be convicted. It gives prosecutors more of a free hand, possibly circumventing the law. And it developed guilty plea cultures amongst defense lawyers. The legal issues in plea bargaining, and there are some. Defendants are entitled to counsel. Pleas must be made voluntarily. Promises made by a prosecutor and defendant must be kept. Defendants' due process rights are not violated when the prosecutor threatens to re-indict on a more serious charge. And it's valid to accept a guilty plea from a defendant who maintains innocence. The Supreme Court has reviewed the property of plea bargaining in several decisions while imposing limits on it. And the court has upheld its continued use of plea bargaining. So, plea bargaining is a part of the system. It's an integral part of the system. And the system will not work properly without plea bargaining. So, if you will, take a moment and take a look at strange plea agreements on page 197 in your textbook. Some things to think about are ad hoc plea bargains reasonable and or fair? Why or why not? And what if the tables were turned and, say, a speeding motorist offered $100 to the officer who stopped her in exchange for leniency? Well, what would happen then? It's just some things to think about as you work through this really complicated issue of plea bargaining.